progress.
Good evening. Good evening, distinguished guests, teachers, and students. I, Supriya Patil, student of first year LLM Department of Law, Mumbai University, delighted to welcome you all to the webinar titled as Navigating the Challenges of Online Content Regulation under the Online Safety Act 2023 and Big Tech Accountability. Before we begin with the education journey, I request everyone to stand up for the national anthem. Please, everyone.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा। विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा। तव शुभ नामे जागे तव शुभ आशीष मांगे। गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
Thank you all. Thank you, Chobe sir. Let me begin this webinar with the introducing our coordinator, Dr. Alka Patil ma'am. It is my absolute privilege to extend a warm welcome to the unwavering force behind today's webinar, Dr. Alka Patil. An intellectual powerhouse and pillar of the legal fraternity, Dr. Alka Patil done multiple hats as an assistant professor of law at prestigious University of Mumbai. Her expertise spans a diverse array of subjects including constitutional law, administrative law, and human rights in India. Armed with formidable PhD in law and a diploma in cyber law, Dr. Alka Patil ma'am begins a wealth of knowledge and insights to her role. In addition to her teaching responsibility, Dr. Alka Patil has made a lasting contribution to the legal field through her innovative research initiatives, provocating writings, facilitating talks at both national and international conferences. Ma'am is the main person who has put together this wonderful webinar with our esteemed speaker, Professor Subhajit Basu sir, for us today. As a teacher, she has worked hard to make sure this webinar will be very informative and thought-provoking. Ma'am hopes we can all learn a lot and have our mind challenged by the discussion. Please join me in giving our sincere thanks and appreciation to Alka Patil ma'am for organizing this great webinar. We are grateful that you scheduled this insightful event for us today, ma'am. Thank you for bringing us all together.
Thank you so much, Ms. Supriya, for the fantastic introduction. Good evening, everyone. I am pleased to welcome you all to today's webinar, where we have the dynamic personality, Mr. Subhajit Vasu sir. Sir is joining from the University of Leeds, London. I had honor of virtually felicitating Mr. Vasu sir to deliver a lecture on balancing freedom and safety, navigating the challenges of online content regulation under the Online Safety Act 2023. This is a big take and acknowledges. This is a highly relevant topics in everywhere. So in an increasingly digital world, the importance of online safety cannot be overstated. So as the digital landscapes continue to evolve, so much to legal framework that governs it. The Online Safety Act 2023 a groundbreaking piece of legislation. It's set to redefine the way we interact with the internet, and in this that the it's day by day it's connected to its effect of individual businesses and the legal landscape. The Online Safety Act 2023 represents a significant step forward in creating a safer online environment for individuals and businesses. With its duty of care provision and the regulated online harms, regulators, categories, and the criticalization of an independent regulators, the Act seeks to strike a balance between the online freedom and safety. Solicitors and the legal professionals will be instrumental in guiding clients through the legal intricacies of the Act and enriching a safer and more responsible digital landscape for all. Therefore, with this, I can efficiently utilize my time as we eagerly anticipated your esteemed lecture, sir. Welcome you, sir. Dr. Professor Subhajit Basu, sir.
Ma'am, I give his introduction.
Yeah, yeah, please.
Yes. Yes, ma'am. Thank you so much, ma'am. Dear viewers, esteemed faculty members, distinguished guests, and dear students, it is with great pleasure and excitement that I extend a warm welcome to each and every one of you to the Department of Law, University of Mumbai, online seminar on the topic Balancing Freedom and Safety. And we have the distinct honor of introducing a renowned scholar and expert in the intersection of law and technology, Professor Subhajit Basu. Our esteemed guest, Professor Subhajit Basu, is a luminary in the realm of law and technology, renowned for their pioneering research and unwavering commitment to addressing the multifaceted challenges posed by digital innovation. With a career spanning academia, legal practice, and international consultancy, Professor Basu has consistently demonstrated a deep understanding of the intricate interplay between legal frameworks and emerging technologies. At the core of Professor Basu's work lies a profound dedication to empowering individuals and communities, particularly in the global south, through informed decision making and robust legal protections. Their groundbreaking research on topics ranging from privacy and healthcare data to e commerce taxation law has not only shaped academic discourse but has also influenced policy formulation and societal debates. As chair of the British and Irish Law Education Technology Association and recipient of prestigious accolades such as the Hind Ratan Award, Professor Basu has been a leading voice in advocating for ethical and equitable approaches to technology regulation. Their extensive involvement in internationally funded research projects underscores a commitment to collaborative, interdisciplinary approaches in addressing complex societal challenges. Furthermore, Professor Basu's role as an educator and mentor exemplifies their dedication to nurturing the next generation of scholars and practitioners in the field of law and technology. Through their leadership as co director of postgraduate research studies and their involvement in various professional organizations and advisory boards, Professor Basu continues to inspire and shape the future trajectory of legal scholarship and practice. In conclusion, it is a privilege to have Professor Subhajit Basu with us today, and we eagerly anticipate the insights and perspectives he will share with us. Please join me in extending a warm welcome to Professor Subhajit Basu. As we embark on this journey of exploration and learning, I encourage each of you to engage with Professor Basu's expertise to challenge established paradigms and to seek innovative solutions to the pressing issues at the nexus of law and technology. Once again, a heartfelt welcome to Professor Subhajit Basu and to all present here today. Let us enlighten ourselves with his expert views on this topic, balancing freedom and safety. Thank you, sir, and most welcome.
Oh, thank you so much for inviting me. Thank you so much, Dr. Patil, for inviting me. Thank you, Faculty of Law, Mumbai University for inviting me. It's actually quite an honor to give a lecture in India, and I'm rather touched and actually nearly brought a tear to my eyes when I heard the national anthem. Um, yeah, well, at the end of the day, I'm always an Indian. Now, good afternoon, good morning. Well, here in England, it is a morning. So, but in India, it's an afternoon. So, good afternoon, everyone. Thank you for inviting me. Now, as has been explained, I will be looking into United Kingdom's Online Safety Act 2023. Now, you may wonder, you may be thinking, why should we here in India be concerned with a piece of legislation that is from United Kingdom? Why should we care? Well, Online Safety Act is not just any law. It is a groundbreaking legislation. And if you look at this legislation along with European Union's Digital Services Act, it is these two legislation put together is shaping the conversation on digital safety and regulation, not just in United Kingdom or European Union, but around the globe. In a world where digital boundaries are virtually non-existent, I know different countries try to carve out their share of internet. Yes, it is possible to do it. China is a good example of that. But what we understand, what we have to accept, that the steps taken by one country can resonate across continents and can have impact on different countries. So, for example, from Germany to United States, from China to Australia, the governments are stepping to regulate social media and other digital platforms. Even if you look at the tech leaders like Mark Zuckerberg, he has been calling out for a need for regulation, and that kind of shows a shift in how digital spaces wants to be managed in the future. And this global momentum reflects a crucial point. Why? Because after years of hesitation, there is a collective move towards tightening the oversight of digital platforms. Why this is necessary? It is necessary because to curb the spread of misinformation, disinformation, hate speech, and of course to enhance public accountability. You know, two of the Bollywood stars have recently filed an FIR in police station because of publication of deep fake videos. And during an electioneering time in India, deep fake videos, misinformation and disinformation can have a detrimental impact not only on our society, but also on our democracy. We all want us to be safe on the internet. And this demand for changes has resulted in big techs or platforms to ramp up their efforts. Well, they have expanded their moderation capabilities, their moderation technologies, but it's not very clear how they are doing it. There is a lack of transparency. And also, there is no legally mandated reason for doing it. They're doing it pretty much on a voluntary approach. So, as I unpack UK's Online Safety Act, I will explore its implications. I will consider its potential as a model, not just for India, but other countries in the world. Now, I'm very cautious about saying as a model for India. I'm not a big fan of countries copying legislations of another country. It simply does not work because different countries have different aspirations, potential, cultural norms, legal system, and the variation in those makes it unwanted to copy a model of another country or a legislation of another country. But in this particular case, Online Safety Act can be seen as a starting point. Not everything, as you will see later on, in Online Safety Act is good, but it's a good starting point. It's a good piece of legislation. I will also discuss the delicate balance of regulating digital spaces without stifling innovation, and also making sure there is freedom maintained in the space. So, what can we learn, and how can these insights shape our approach to digital safety and governance? So, I'm going to discuss that a little bit later, but before that, let me tell you that UK's Online Safety Act 2023 received royal assent on 26th of October 2023. Majority of its provisions entered into force on 10th of January 2024. So this is earlier this year. The legislation introduces a pioneering regulatory framework designed to combat illegal and harmful content on the internet. The ambition of our government is simple and clear: to make the UK the safest place in the world to be online. The legal implications, if you look at the legal implications of this law, they are far-reaching, affecting not only the largest tech companies, but also a wide selection of websites and applications that offer user-to-user services such as discussion forums and even search services. You can say that this comprehensive approach recognizes the evolved landscape of social media and digital platforms, where we are increasingly seeing illegal and harmful content having unprecedented impact on users, on us. UK government argues that this law is designed to balance the need for safety, but at the same time, it is preserving our freedoms. Now, this is the thing which we need to understand. This is the thing we need to explore. So I will discuss the broader implications for big tech's accountability, considering how the major platforms are now have to navigate the ethical and the legal demands of content moderation and also ensure user rights. What is not very clear about is, in an attempt to do content moderation or content policing, whether they will be ensuring, whether they will tilt towards more of content moderation and less about protecting users' right here. So for your fundamental right to freedom of speech and expression. And I want you to think about is that how do we define the boundaries of what is actually a harmful content without encroaching freedom of speech and expression? And also you have to remember freedom of speech and expression varies from country to country. It is in no country it is an absolute right. And so is the problem with what it can be termed as a harmful content. So what responsibilities should the tech companies have? How can they be held accountable in ways that it respect user safety and at the same time it also respect user privacy? Now, UK's approach to regulating big techs and platforms underwent a profound transformation that started when Theresa May was British Prime Minister. And this has happened. There are a number of reasons for it, but there are two major crises which started this. One of them was the tragic death of Molly Russell, and her death has been linked to harmful content on social media. And of course, the Cambridge Analytica scandal, which kind of created a bit of a panic around the world because it exposed the exploitation of personal data. And this incident also showed us the limitations of self-regulation by the tech companies and by these platforms. So for a long time, these big tech platforms, Meta, Amazon of the world, they have been self-regulating themselves without actually clear legal mandates. Now, this particular incident at least galvanized the calls within United Kingdom for a government intervention, particularly after the Cambridge Analytica scandal. And at the same time, as the political leaders in the United Kingdom were grappling with these challenges, we had the very unfortunate incident of murder of UK member of Parliament David Amess. And that murder also intensified the demand for a robust online regulatory framework, a robust online safety measures. Now you can understand that these are very complex backgrounds. So on one side, you have a problem with data, where data has been misused by a company like Cambridge Analytica without our knowledge to manipulate us, to manipulate our thinking, creating echo chambers. And on the other side, there is this need for safety for us and people in public life. And both of it are actually threat to our democracy. So this complex backdrop set the stage for United Kingdom, for our government, to rethink its regulatory framework. And it wanted to balance the technological innovation with user safety and data protection. What resulted from it was this legislative effort which reflect a critical juncture in the ongoing debate over digital governance, how it should be done, what is the best way of doing it. You can see different governments around the world taking different steps. China's approach to it has been fundamentally different from Western liberal democracies. But there is a point of convergence where both countries or group of countries agree that there is a need for regulation. But this also illustrates the different dynamics, the intricate dynamics between technological advancement, public policies, and societal values. And these societal values, unfortunately differs from countries to countries. Now, one thing I can tell you, I have very little sympathy for big techs and or platforms, as you would want to name it, because the way these big techs and platforms have been exploiting us, manipulating us. They have been using algorithms and now even AI to curate content for us as users, primarily to boost engagement for profit. We know Twitter and Facebook through the whistleblowers, when they gave evidence in the US Congress, that they have showed advertisement to children which should not have been shown to them, and they did it for the purpose of maximizing their profit. So we have often seen potentially illegal material because the way their algorithms have been designed to show content which increases their profitability. Now, from its inception, this particular legislation, Online Safety Act, aimed to navigate the complex terrain of legal but harmful online content. And this was controversial from the very beginning. You understand something legal, but it is harmful. And our government wanted to regulate that. And it sparked a debate because it was difficult to see how you can regulate something which is legal, but at the same time harmful. And at the same time, you can ensure protection of enough expression and privacy rights. How are you going to balance that? And we have argued that this method, this provision of controlling or regulating legal but harmful content actually grants excessive control to big tech because they kind of decide. Well, there are two sides of this argument. The people who believe, the proponents of it, they saw that it is a necessary step towards addressing the rapidly evolving challenges of digital content, where it is difficult to demarcate between what is harmful for a person or a vulnerable individual, but it is still legal, and probably it will not cause harm to the general public per se, but can cause harm to a vulnerable individual. For example, harmful content related to, say, eating, dieting. Now, there can be content related to dieting which is completely legal, but that can have a detrimental impact on someone or an individual who is suffering from anorexia. Okay, and then there are instances of information related to self-harm. It can also have an impact on individuals who are vulnerable. So a lot of this content are legal, okay, and probably falls within the purview of freedom of speech and expression. But just because they are legal doesn't mean that this speech, this expression, this content are not going to have a detrimental effect on the society or on us as individuals. And the UK government showed an interest in regulating that content. Now, the law's journey underscores the need for clarity on the legal parameters of expression and privacy. Because ultimately, as a liberal democracy, it is the responsibility of our government that on one side it safeguards us, it protects us, but on the other side, it has to ensure that it protects our fundamental rights. So some of these controversies around this legislation, the provisions that were included in this legislation at the beginning were less about what is there in the legislation, but more about what was actually not included in the legislation. There was no clarity given what exactly you mean by legal but harmful. What would be the legal and harmful? Okay, and a lot of the way the legislation was framed was left on the big techs for them to decide. Now, this legislation has gone through the parliament for perhaps one of the longest time in history. It also means, because it started when Theresa May was the prime minister, and it just got enacted last year. And when this legislation was going through the parliament, this legislative process and this legislation had the misfortune of having to go through during the COVID-19 pandemic. But because the legislation went through the time of COVID-19 pandemic, it also gave the legislators a live view of the impact of information, particularly disinformation and misinformation, can have on society, because it saw the spread of anti-vaccination, anti-lockdown messages that became a threat to public health initiatives, not just in this country, but across the world. And after the worst of the pandemic was over, those same falsehoods fade into other conspiracy theories, and that continue to disrupt our society, disrupt our way of life. If we look at the original white paper, so in UK, most legislation starts with a white paper, and that white paper gets publicly available for a purpose of consultation. And then it slowly becomes a legislation. So white paper, you're given the opportunity for general member of public to have an opinion about what do you really think about this law. You can see a similar initiative in India with the data protection law. Although a white paper wasn't published, but the data protection law was put through consultations and people were invited to give their opinion about it. It is a very good way of framing law. But this bill's foundation included proposals for compelling platforms to tackle this legal but harmful content. But as I said, it is not included in the final legislation. But if you look at the legislation, it is a long legislation. I will talk about it a little bit later. It does create a new offense of false communications. It criminalizes communication that deliberately causes harm by communicating something that the sender knows to be untrue. Well, at the time of initiating this legislation, our government thought it is going to be a world-beating legislation. Unfortunately, it didn't turn out to be a world-beating legislation because European Union's Digital Services Act came into force in August 2023. Now, if you look at this legislation, as I was telling you a little bit earlier, this legislation has got 200 clauses. It is a long piece of legislation. It runs nearly 300 pages, and it covers a wide spectrum of illegal content that platforms is now required to address. And it also gives platforms a duty of care, over what their users, particularly children, see online. And some of the more nuanced principles around the harms caused by legal but harmful content have been watered down because of the opposition that I had been telling you about. And has been watered down, but there are highly divisive requirements for messaging platforms to scan users' messages for illegal material, such as child abuse material. Now, you can understand, so this law is mandating that a company like WhatsApp needs to scan the messages which you and I send to each other. Now, it is problematic. And of course, the tech companies and privacy campaigners say this is actually an unwarranted attack on our privacy. It is an unwarranted attack on encryption. What this law actually means is under this law, the platforms is expected to police potentially harmful but not illegal content by applying their own standards more consistently than they currently do. Now you have to understand, so how are you going to scan it? Which means that you have to create an algorithm which scans pretty much all messages that gets sent around in a platform like WhatsApp or Signal, in order to flag those messages which this law mandates to be illegal. And this is something that free speech campaigners like myself found rather difficult to accept, because it gives a company like Meta, Facebook, which kind of owns WhatsApp, a control over our messages, a control over what is acceptable discourse online and what is not acceptable discourse online. So this company technically gets a lot more power. And because it is already mandated in law, and I hope that the compliance with the law will require platforms to be a lot more transparent and proactive, because, well, the law has been enacted, and Ofgem, which is the regulatory body, I will talk about Ofgem a little bit later, they are now drafting the rules. So from the laws, you need the rules that these companies will have to comply with. I will come back to this again. But at this point, I think it's very important to talk about a little bit more about what I mentioned a little bit previously, the duty of care in law. Now, if you look at both the UK legislation and the European Union legislation, both these initiatives are grounded in the common law duty of care, which holds that the providers of goods and services have the responsibility to anticipate the adverse effects of their offerings, this good or the service they are offering. And if they think that there are possibilities of risk associated with it, they have to take steps to mitigate those effects. Now, you know, the tort law of negligence is rooted in the duty of care. And why this was necessary? Because there is a belief, and it is quite right, the digital platforms, the big tech companies have failed to exercise their duty of care sufficiently. Now, both UK and United Kingdom's initiatives, if you look at these two legislation, both of these legislations are based on identification of the risks created by the platforms and how those risks has to be mitigated. There was no responsibility for risk mitigation, even if they identify those risks to mitigate those risks. There was no responsibilities on the big techs or the platforms to do so. And you will be surprised, or probably will not be surprised, if I tell you that the electric kettle you have in your home probably had a lot more risk assessment and risk mitigation done than the software you are using, or a particular product you are using in an online environment. So these risk-based systems are completely different from old industrial era of regulatory micromanagement. So what does two legislation do, rather than a top-down approach of telling the social media companies, these big techs, these platforms, that you must run your business in a particular way, because that is what the regulation mandates. The law now provides a rather risk-based approach, which involves the government working with these companies to identify the harms and create a mitigating strategy. You can see something very similar if you look at ransomware related rules and legislation that has come out in United States also. This attempt to mitigate it. Now, this has happened. Why this has happened? Because big techs have consistently failed to take responsibility voluntarily. Okay. And obviously, something had to be done, and the governments had to step in. And UK government had to step in, the European Union had to step in. And if you listen to the policies and the statements given by the ministers in the Indian government, you will get an impression that the Indian government wants to do something very, very similar. And one of the first issues that this particular legislation, I hope, would tackle in 2024 is in relation to online harmful content for children. Now, there is two things about my work. On one side, I have always argued for content moderation. I've always argued for the need for content moderation. And it makes me very uncomfortable now. The Elon Musk's Twitter X platform, now they do not do the level of content moderation or content policing system than it used to be under Jack Dorsey. So it has changed. His policy has changed. His outlook has changed, which makes me uncomfortable because now there is a lot more vile on a platform like Twitter than it used to be. But at the same time, I also didn't really feel very comfortable when Twitter decided to deplatform President Trump, not because, I've got great fascination for Trump, I don't, but because the way it was done and based on which grounded principles, because there has to be a transparency in the process, there has to be consistency how you apply these rules. And it makes me uncomfortable that an elected leader of a particular country can be deplatformed. But at the same time, there is no right not to be deplatformed. Okay, after all, this is a private entity. When you signed up for an account in these facilities, you agree to subscribe and follow certain community guidelines. The problem is these community guidelines are not always very clear, and neither they're always applied consistently across the world. So, as I've always said, that it is never going to be easy, and particularly from a freedom of speech and freedom of speech and expression point of view, it is never easy. Why? Because I did touch upon it a little bit towards the beginning of this lecture, because no common definition of problematic content exists across platforms or problematic content exists across jurisdictions. The content moderation guidelines are often inconsistent, and in most of the time, they tend to be applied in a politically motivated manner. Okay, a lot of conditions, you will see that this content moderation guidelines are applied, maybe trying to satisfy the demands of a particular government rather than looking after the interest of an user or protecting free speech. So what is deleted by one platform still can be accessed in another platform. As a result, users who get censored on one platform, they can very easily relocate to another platform, because for a time there was a monopoly of these platforms, but now it isn't. There are alternatives available to X, there are alternatives available to something like Facebook or Instagram. So you can see that Trump's supporters moved away from Twitter to Parler. I'm not supporting, Trump supporters are not advocating that they're doing a great thing, but I'm just showing that what is possible, because there was no regulatory framework which will regulate both Twitter and Parler. And in addition, content moderation has been criticized for being too slow. And this is perhaps where this law has been quite good. The law has now appointed the Office of Communications, our Ofcom, as an independent and impartial regulator. I am emphasizing on this point of independence and impartial regulator because it is necessary that a platform does not get unduly influenced by a government in power. And this is why having an oversight mechanism, an oversight body which is independent and impartial, is so important. You remember I talked about balancing rights. This is hoped that this regulator will ensure that. Ofcom is required to provide guidance and is now in the process of setting out codes of practice for them to comply with their duties under this legislation. Prior to this legislation, most user-to-user platforms, search services that were operating in United Kingdom were not subjected to any regulation concerning user safety. If you look at the previous regulatory framework for regulating internet services, the primary legislation was European Union's E-commerce Directive 2000, which was implemented in UK law because we were part of European Union at that time. Now, the liability for internet service providers under this directive was limited. This new legislation greatly increases the responsibility of the providers of regulated services for their content on their platform. And as I said before, the law imposes numerous duties on them to identify, mitigate, and manage the risk of harm from illegal and harmful content. This legislation also introduces various communications offenses that apply to individuals and companies, such as false communication offenses, threatening communications offenses, and offenses of encouraging or assisting self-harm. So not just big techs, down to the smaller platforms and messaging apps will need to comply with a long list of new requirements, starting with age verification of their users. Even the pornographic websites now have a requirement to ensure age verification of the users. But this is not plain sailing. Wikipedia, the 8th most visited website in United Kingdom, has said that it won't be able to comply with the rule because it violates Wikipedia's foundation principle on collecting data about its users. So you can see, even when the law is there, it is not going to be that easy to enforce it. And at the end of the day, as lawyers, we know law is about enforcement, the control. Okay? So yes, the platforms will now have to prevent younger users from seeing age-inappropriate content, such as pornography. The platforms have a responsibility to ensure that younger users and vulnerable users are not falling prey to cyberbullying and harassment, well, that also extends to every one of us. They have to, very importantly, they have to release risk assessment of potential dangers to children about their services, which is important. They never had this provision that whatever they have introduced, what are the chances that this is going to have a detrimental impact on children? And there's now this law gives parents a much easier pathways to report those concerns. So, sending threats of violence, including rape, online is now illegal. It is also illegal to transmit deep fake, including deep fake pornography. What you saw in India in the case of the two Bollywood stars, and also in the incidents of Rashmika Mandana, whose image was defaked. So that becomes illegal. It does, in Rashmika Mandana's case, does fall under, it is possible to bring under 2021 IT rules, but it's not that robust. The Safety Act has a lot more robust provisions, but then again, Indian government is in the process of introducing a new legislation which will replace our old IT Act of 2000. I'm quite cautiously use the word our when I refer to UK and when I refer to India. I know that. Yeah, but I think it's quite clear to you when I say our in a particular country's context, because both are my country at the moment. So big techs and platforms will need to quickly act to remove these contents from their platform, along with scam advertisements. Now I'm going to go back, as if you remember, I did mention that I will come back to discuss about the provision, which is the most divisive provision about scanning. Well, that provision is Section 122 of Online Safety Act. And it has been widely interpreted as a provision compelling social media companies to scan user messages to ensure they are not transmitting illegal material, which I have told you before. Now, as I said, this is going to be incredibly difficult and even possibly impossible to do without breaking the end-to-end encryption on platforms like WhatsApp and Signal. WhatsApp gives us that assurance that it is end-to-end encrypted, and that gives us the privacy. Okay, it is important, but then at the same time, it is also important that these WhatsApp groups, that India is going through electoral process. UK will very soon have elections in this country. We saw it during the pandemic. We saw it during Brexit. This WhatsApp group, this phenomenon called WhatsApp University, where people indiscriminately, without thinking, share information which are blatantly false or disinformation, which means an information that has been created to manipulate or misguide the population. So yeah, there are two sides of it. You know that end-to-end encryption means that the sender and the recipient of a message can see its content, but the owner of the platform on which it is sent cannot, any point of time, will be able to see that content. But if you look at the provision of Section 122, the only way a platform can comply with the law would be to put in place the so-called client-side scanning software on users' devices to examine the messages before they are sent. Now, Obviously, this would make encryption largely useless. Okay. And also remember, this software, this algorithm has to be downloaded into the device, which can also mean that this software possibly have the capability to monitor your other activities. I'm I'm not saying it will, but there is always that possibility because we do not always know what these things do, what these algorithms do, what these softwares do. And some of the times the people who develop it can't really predict. And if you throw artificial intelligence into it, it would become nearly impossible to predict. Now, UK government said during the time when the bill was going through the parliament that, well, at the end of the day, we are creating this law. Now, this is up to the social media companies that they should find a technical solution to scan the messages without underpinning encryption, without being a threat to privacy of the users. What we know that none of the social media companies, even the experts in the field, none of them could give an assurance like that. And they said that the technology does not exist. And some even went on to say that this technology will probably may never exist, where on the one side there is scanning going on, and on the other side there is encryption. Can't be possible. So I would wish to end this lecture. I was thinking what would be the best way to end this lecture. You know, there is a very old saying, man proposes and God disposes. Sometimes we do not know what we want and then we get it, and we again do not know why we wanted it first place and what is the implication of it after getting it. Actually, I can quote Oscar Wilde, who warned of life's two great tragedies. One is not getting what one wants, not getting what we want, basically, it means. And the other is then getting it. So we now have a law, at least on paper, would make us safe, but it's also a law which has provisions that we may find difficult to comply with. These platforms may find difficult to comply with. And also, we may find as users not getting what we wanted, that balance I talked about between rights and responsibilities, between privacy and security. Now, for years and years, these big techs and these platforms have successfully used their economic, political power to prevent governments across the world from acting. And then you had people like Mark Zuckerberg openly saying, oh, well, we want regulation. We want governments to regulate, and that will be good for us. We never had a clarity what we should be doing and not be doing. Now, one side you can see they have achieved what they wanted. European Union legislated through Digital Services Act, UK legislated through Online Safety Act. You can find a similar legislation in Australia. And obviously, Indian government is in the process of introducing a new legislation which will have provisions related to it. So what is the reality the big techs are facing? Well, countries around the world will be making new rules. What is happening, or what has happened in London or Brussels, is creating a de facto global digital risk management standard. And I'm quite confident India will follow something very similar. Because if India doesn't, then it will find itself in a very difficult position where, on one hand, it can see the need to ensure safety of the users, but on the same hand, the government doesn't want to drive these big techs away from the country. What? Yes, there is a global standard, but what I would like India to do would be to develop its own policy framework, dependent upon its own need. But yes, I want the Indian government to respond. I want to see how the Indian government responds to it. But at the same time, I want to see a balanced approach by the Indian government, a balanced approach between protecting the fundamental rights that are enshrined in the Constitution of India, while at the same time ensuring safety of users and respecting the need for national security. That is all I have to say. Thank you so much.
Thank you so much, sir.
Thank
Yes,
you.
Priya. So, Priya,
Yes, ma'am.
yeah, please.
Sir, with respect to your lecture, I have one question. As in this act, we mentioned that this act governs particularly online safety measures of users. So I would like to know the ambit of this word user. For example, users means only the citizens of UK, or if suppose I am in the territorial jurisdiction of the UK and perform some activities which are illegal, or some activities performed by others uh, that can be considered as illegal from my side, then can I file case or I come within the ambit of the term user?
Yes, you do. You do come. So if you are within the jurisdiction of the United Kingdom, whether it doesn't matter whether you are a citizen or a non-citizen, or even if you're a tourist, you can flag up that particular content to a platform to say that this is an illegal content, this is a harmful content. So you do get that protection. Interestingly, the Online Safety Act does have a bit of an extraterritorial reach, which is something we have been seeing nowadays with a number of legislations. You can see it in GDPR, and you can also see it in India's data protection law, where it kind of tries to regulate uh, content which is not necessarily being posted from within its jurisdiction. And it is quite an obvious because a lot of content gets created in different parts of the world. That is the beauty of the internet. But there is a need to regulate those content. Now, how far that extraterritorial reach will go, if you try to prosecute someone who is not within your country, is something to be seen. But then on the other hand, the law is quite clever in that way. It's not trying to prosecute the user who posted the content or said something harmful. Its reach is on the platform. So this American companies, most of them are actually American companies, now will have to be governed by the rules and the laws of United Kingdom or European Union, depending upon which jurisdiction is going to use the provision. So yes, so you can't control the user, but you can control the platform. So it's kind of like, making sure you control the neck so that the head knows where to turn.
Okay, thank you, sir. Thank you for clearing my doubt. So the next question is, we are talking about the harmful content, right? So suppose any content is harmful according to me. Okay, some content is harmful according to your other person. So is there any standard test to decide whether any content is harmful or not with respect to this act?
Yes, so the government, so this is where the controversial part of the legislation was at the very beginning. So the government of UK wanted to say that we want to regulate legal but harmful content. And then it couldn't provide a definition. What do you really mean by legal and harmful content? Now we have a much more clarity. The legislation actually says what are exactly the illegal acts that we want to regulate. And that includes disinformation, deepfake, that includes bullying, that includes content which are inappropriate for children, self-harm content, content related to revenge porn, although we do have a legislation which regulates revenge porn. So the legislation provides a lot more clarity on what type of content needs to be regulated or what type of content needs to be monitored or prevented from users accessing it. And also the Ofcom, the independent regulator, is now creating a code of practice, is going through giving a lot more guiding rules to ensure that the platforms have some more clarity on what type of content is classified as harmful and what is not classified as harmful. It is not going to be easy. There are certain things which is quite easy. Obviously, you know what is revenge porn, or you would know what is a racist content, or know what is a hate content. But the problem is it's not very easy to define what is a racist content. Now, if you look at the Prime Minister of United Kingdom, he says his aim is to stop that boat. Now, stop that boat can be interpreted as a very racist content, but it is a content related to immigration, related to illegal immigration coming to this country. So when it comes to content, when it comes to free speech and expression, there is no global consensus. It depends, if you look at the world politics now, the war between Ukraine and Russia, depending upon which side of the particular individual is, people have an opinion and can express that opinion. If you look at the Palestine and Israel conflict, it is the same issue. It depends upon where you stand, and some of it can be subjective. So it is not always very easy to say what is acceptable and what is not acceptable. If you look at India, you see the same problem. Democracy is about dissent. Okay, what makes Indian democracy so beautiful and so robust is that right to dissent. In a democracy, the government or the ruling party does not make it a democracy. It is the opposition which makes a democracy. Because you have an opposition, that is the rule where you have a democracy. That gives you the perception of democracy. Now, a government can interpret anything anti-government as unacceptable, as harmful, and big tech can comply with it. Okay, so it remains to be seen how those are going to be applied and implemented. Twitter X has now taken a policy where they are kind of pushing the boundaries of free speech. Of course, in the United States, you have the First Amendment protection, but even then, it's not an absolute right in the United States, but it does have a First Amendment protection. Freedom of speech and expression is given more priority. On the other hand, in Europe, we are a lot more right-focused. We are a lot more because pluralistic society, a lot more tolerant to ensure that certain speech do not get platform. Similarly, in a democracy like India, we will have the problem determining what is acceptable and what is not acceptable. I did write a paper about silencing voices in India and how it is applied, to try to find, where the government is going and which direction it wants to go. But these are some of the challenges the Indian government will face while introducing the proposed new legislation, and how it will deal with it will ultimately determine whether, as user, we have freedom of speech and expression, we have our privacy, or we don't.
Thank you, sir. Thank you for your explanation.
Yeah,
Vidya?
Rossi.
Yes, ma'am. Yes, ma'am. Yes, ma'am. I will give the vote of thanks. On behalf of Mumbai University Department of Law, I extend my heartfelt gratitude to Dr. Alka ma'am, renowned guest Professor Subhajit Basu, colleague Supriya, and all the dedicated staff and viewers who contributed to the success of our YouTube webinar today. Your expertise, dedication, and active participation have truly enriched the webinar, making it an insightful and memorable event. Dr. Alka ma'am and Professor Subhajit sir, your invaluable insights and guidance have illuminated various aspects of the topic, leaving us with a deeper understanding. We also extend our sincere appreciation to colleague Supriya and all the staff members who worked tirelessly behind the scenes to ensure the smooth organization and execution of the webinar. Your hard work and commitment have not gone unnoticed. Last but not least, we are grateful to all the viewers who took the time to attend the webinar, engaging in fruitful discussions and contributing to the exchange of knowledge and ideas. Thank you once again to everyone involved for your unwavering support and dedication. We look forward to more enriching collaborations in the future. Warm regards. Thank you, one and all. Thank you, ma'am.
Thank you so much.
Thank you
Thank
so
you
much.
for inviting. Thank
Thank you
you.
so
I
much,
look
sir.
forward. Thank you. Thank you, ma'am. Thank you.
Have a good day, sir.
Same to you. Thank you.
Thank you, sir. Dear students and respected sir, now this the link is going to be in. Thank you.